effort on the part of a committee to subpoena either the document by way of a subpoena ducis tecum, or even invite the participation of a judge with respect to a pending case. And several times, that section in our House rules regarding constitutional legislative inquiries where there is a pending case is often cited, that it cannot be cited as a sub judice matter for as long as we are not discussing the merits of the case. In this particular case, Mr. Chairman, the House asked for documents specifically from a judge. The judge could have responded to us directly, maybe citing that there's a pending case and therefore he cannot provide the documents being requested. We can accept that or not accept it. We can press for the submission of the documents, in which case there's going to be a clash between the House and the judiciary represented by the judge. It may go up to the Supreme Court. We are not here to interpret who would be in the right position. But in this particular case, like I remember in one committee, in the Committee on Housing, there was an instance where a judge issued a TRO that prevented some homeowners association from pressing for what they felt was a right with respect to housing. Since the judge refused to honor the invitation of the committee, the members of the committee, not the committee itself, but the members of the committee, this representation included, was compelled to go to the Supreme Court to file an administrative case against the judge. That can be one option. In other words, we can say that the judge is not performing and therefore submit the judge to a possible administrative case. The other option is to elevate it, and I think maybe the judge will be the one to elevate it to the Supreme Court. But I thought that maybe the more respectful reply of the judge would have been to make that response himself instead of immediately summoning no less than the court administrator of the Supreme Court to face us here in the committee. I think it may be a little premature as far as I'm concerned for the face of the Supreme Court to be here immediately instead of the judge himself making the response. Why is the judge not responding to us directly? Maybe he can say that he's still consulting his higher authority instead of immediately the Supreme Court spokesman himself or court administrator himself being present here when he did not invite him, Mr. Chairman.
Yeah, Congressman Golez, the last hearing, the Judge Villardon actually replied, and also an official of the other branch, the branch 98 of ITC, and they stated in their letters that they referred the matter to the court administrator. That's why we invited the court administrator for today's hearing.
Yes, but we have, I think we have to speak for our colleague, the Honorable Elpidio Barsaga, because he's pressing for a more conclusive response from no less than the judge. Hindi yung irereto tayo dun sa taas, Mr. Chairman.
Kaya, Congressman Joaquin.
Thank you, Mr. Chair. Just very, very briefly. I think what needs to be underscored is most of us here are lawyers, and we in fact give due respect and honor to our duties to the court. I think that needs to be underscored, that when we do our legislative duties, we are likewise bound by our professional duties as magistrates, or at least as officers of the court. But having said that, I think it should be underscored that without denigrating the office of the court administrator, which is an office I personally highly respect, this matter is a matter that requires resolution from the court itself. Meaning, the subpoena was issued no less than the Speaker of the House, endorsed by the Chairman of the Committee on Justice. It's not simply an action by this committee, but this is an action by the House of Representatives. and an action is required from the court. And principally, we have strongly manifested that we do not in any way want to go into the merits of the case. We are not here to evaluate the performance of the judge. There is an important legislation that requires action on our part to be able to protect the interests of citizens. Not only that, the Congress is setting aside a substantial budget, or at the very least will eventually be financing the entire computerization of the LRA. That will eventually require, or at least is requiring already, appropriation coming from Congress. We need to know if in fact these systems that the government is funding will in fact work. Or will these same problems involving thousands of citizens who have long paid for their properties can just be removed or asked to vacate the properties that they've had for quite some time? I think that the court has already acceded. The judiciary has acceded already when the sheriff of the court presented himself to this August committee. He has already testified under oath. So by that measure, the court has already acceded to the jurisdiction of the court as far as the case is concerned, or at least the records of the case. So I cannot also imagine, without preempting the court, or at least the NBank, is that the court itself, at least the RTC, has already accepted and embraced the jurisdiction and authority of this committee. I cannot imagine that we will accept 50% but not accept the authority of the committee in its entirety. Like I said, the direction I'm simply saying, Mr. Chair, is that without disrespecting, or at least devaluating the opinion of the court administrator, I think it's time to come to a head for the court to make a decision, because like as what Congressman Golez said, uulit at uulit na naman po ito, siguro malaman na natin talaga hanggang saan at ano yung po pwede. Because kinakailangan ng committee ito yung hinihingi naming records. Hindi namin hinihingi yung actual records because the court will remain as the custodian of those records. Congressman Farinas has often said that we are simply asking for certified copies that we can have access to so we can completely evaluate what laws need to be changed or amended, and most importantly, what appropriations, which in fact we are already giving to the Land Registration Authority. Will this appropriation work or not? Thank you, Mr. Chair.
Yeah, but before
Ito yung paupuin lang. Sheriff, upo ka naman, no? Katayo ka dyan eh. You are a
Sheriff, you.
Please take it, Sheriff. Upo ka, Sheriff. Katayo ka dyan eh.
Mr. Chairman.
Yes, Congressman Golez. Congressman
Just make an additional.
Yes, please go ahead, Congressman.
Just make an additional comment with respect to the comment of with respect to contempt. It does not mean the Speaker's action. The contempt on the committee of the House is considered contempt of the House itself, because we are acting for the House. We have the mandate of the House here, Mr. Chairman. So, well, maybe eventually we'll have to arrive at the situation, hopefully not, to determine how we should treat this action on the part of the court. If we fail to get the cooperation of the court on a matter that does not involve taking up the merits of the case, on a matter where we are seeking the opinion and even some learned guidance from the court itself on something that affects the entire Filipino people, because land grabbing, fake titles are very pernicious, Mr. Chairman. It affects the economy. In fact, they can be considered economic sabotage of a severe magnitude, Mr. Chairman. So may I just, thank you for giving me.
Thank you, Congressman. Before I give the floor I'll give the floor first to Congressman Manny.
Thank you, Mr. Chair. I would just like to emphasize the importance of this case in the light of public interest involved. There are just too many people who are affected, and this strikes at the very heart of the torrent system, where you have a lot of titles, double titles at that, gain the possession of as many people as there are. And in the last hearing, I asked in particular the Deputy Administrator Raul Villanueva of the so many cases, and I can name a lot of cases here. This is a March 15, 2005 case in criminal case number 124841-52. And the next trial date is scheduled February 13, 2012. There is another case involving Piadeco. This was a 2007 case. There was this is before the Provincial Prosecutor's Office in Malolos, Bulacan, docketed under IS number 07093924. So I'd like to pass this to DOJ, and I also requested DOJ to update us on all of these cases. In the May 14, 2008 case involving IS number 285208 for illegally occupying complainant property using título de propiedad. Again, this is still pending before the prosecutor of Quezon province. Worst is in the Teodoro Calo case involving Domingo Sumulong Rojas. There was in fact a decision declaring in clear and convincing terms unequivocally that this
Bakit mga subsequent claims
DCT number 56089 is null and void.
Kaya
And this is known to Mr. Torres.
yung Esteban,
Again,
yung Pedro
on 12
Esteban.
August 2008, there is another case and so many other cases. And this is precisely why I think it's about time that the Supreme Court should move and move with dispatch. And even the DOJ should move and move with dispatch in resolving all of these cases because of the public interest involved. And we cannot dilly-dally, we cannot wait for the Supreme Court before they will rule on the matter and back. This is just a certified true copy of documents that we are requesting that will guide us in formulating legal or legislative issuances, laws, or regulations. So, Mr. Chairman, this is what I emphasize. 15th Congress is just 2 years away from its closure. And if we will wait for Supreme Court to rule on the matter, we may never see the end of this case or this investigation within this 15th Congress.
Okay, Congressman Octoboer, just
Sure, yeah, just one sentence. Allow me to put the issue into from a different perspective. You know, if the judiciary can look into the records of the House in order to arrive at a decision, of course, you look into our judicial proceedings in order to look at the legislative intent, then the House of Representatives or Congress has also the right to look into the records, have access to the records of the judiciary in order to enact laws. So I don't see any reason why our committee should not have any right to look into the records of the judiciary. So, Mr. Chair, from a different perspective, kung sila nga ay tumitingin sa ating records, then tayo din dapat may karapatan na tumingin sa record ng hukuman. Thank you, Mr.
Okay,
Chair.
thank you, Congressman Octoboer. Yes, Court Administrator Mike.
Thank you, Mr. Chair. We, of course, fully recognize the powers and authorities of this committee to conduct legislative investigations in aid of legislation. There is no issue to that. The reason also why I decided to come here was because to move for a reconsideration on the part of this committee in the issuance of the invitation to the judge and the issuance of the subpoena. Basically, on the ground of existing jurisprudence, as I mentioned, there might be a difference in opinion. Again, this is a request for a reconsideration on the part of the Office of the Court Administrator. However, as Congressman Farina said, if there is a need to elevate the issue to the Supreme Court itself, then maybe the Office of the Court Administrator can do that. In the meantime, Your Honor, I would suggest that we can get the records of the case from the other parties, because I'm sure all the parties in this case have records of this particular case. I'm also concerned, Your Honor, when it comes to, let's say, okay, granting without admitting that we release the records from the courts, no? And the members of this committee would begin to investigate these records. Someone will have to testify on those records. What happened? Why this order was issued at this time, or why this decision or ruling was released at this time, and it might go back to the point of the judge being called to the hearing, and that is what we in the Office of the Court Administrator is appointing. Your Honor, just to show that we really have utmost respect for this committee, and we support the investigation being conducted by this committee, we brought with us judges with decades of experience, and they can tell Your Honors the problems regarding land issues, disputes pending before our courts, particularly in Quezon City. Quezon City is a problem area, considering that sometime in the late 80s there was a fire in the Register of Deeds, in the City Hall, which burned all these titles. And that is therefore there are duplications in title. Your Honor, our judges are free to lend to this committee their expertise on the matter, Your Honor.
Congressman Escudero.
Yeah, Mr. Chairman, very briefly. I'm not a lawyer, by the way. I'm a veterinarian. I took only 3 units of veterinary jurisprudence. Kaya hindi ako sasalita ng mahaba. Itong problema namin, hindi malulutas ng magagandang speech. So, Mr. Court Administrator, we want to see the records. Kasi sindikato itong gumagalaw dito. The latest information we got from the Solicitor General. The Soldiers Office failed to make an appeal because when the court copy came to the Solicitor General's office, a clerk of that office hid the copy. Pinagtutulungan na kami. And we were not a party to the case. The 400 or so owners. So we cannot even ask for a copy. What is so about the copy of the case? Para malinawan, Mr. Court Administrator, ito. Para malaman namin kung sino ang mga demonyo sa gobyerno. Once and for all.
Hearing is suspended for 1 minute.